Good afternoon. This is the first session that we will do on confessions. This session will deal with confessions and due process, or the 14th Amendment. The rule is basically is that if Miranda is not given as a violation of the Fifth Amendment, and confession shall not be admissible. However, we should not forget the 14th Amendment analysis when we deal with confessions. And that's where confessions generally started historically, when there was no Fifth Amendment and exclusion of confession when there was a failure to give Miranda. Confessions were generally determined whether they were constitutional under the 14th Amendment due process analysis. The 14th Amendment due process analysis, as any other constitutional analysis, if a person is going to relinquish his right to that due process requirement, we must show that that relinquishment is voluntarily done, that the confession is freely and voluntarily given. The first case we want to look at, the premier case, the cornerstone case in reference to the confessions in the 14th Amendment, was Brown versus Mississippi. Brown versus Mississippi basically says that the due process clause requires that the state shall be consistent with the fundamental principles of liberty and justice, which lie at the base of all of our civil and political institutions. Police cannot use physical conduct or physical force to extract the confession. The use of physical force is a violation of the 14th Amendment due process. Then we went on to the case of, and then we go on, to the case of Haynes versus Washington. In Haynes versus Washington, the defendant was arrested on suspicion of robbing a service station. He asked to call his lawyer. Several times he asked, but was told he could not call his lawyer unless he confessed. He asked to call his wife, but this also was refused. Wife called, but she was not given any information, and she was not permitted to speak with the suspect. The court held the incommunicado detention and interrogation is coercive. The question in each is whether the defendant's will was overborne at the time he confessed. In short, the true test of admissibility is that the confession is made freely, voluntarily, and without compulsion or inducement of any sort. Confessions must be freely and voluntarily given, as it was stated in Brown, with compulsion and without compulsion or inducement by the state of any sort. The question is, was the defendant's will overborne by any compulsion, any inducement by the state? Did he give his confession? Did he give his confession because of police actions or for some other reason? If he gave it because of police actions, it's going to be a violation of the 14th Amendment due process clause, and thus the confession will not be admitted. After Haynes versus Washington, look at Watts versus Indiana. Watts versus Indiana, the suspect was questioned by several officers and shifts almost continuously for 6 days. He gave confession and then was questioned by a second prosecutor to get a better confession. The court said that mental compulsion is also prohibited. Mental compulsion or any ploys that the state may use in order to overbear the person's will to force the confession is going to make that confession a violation of the 14th Amendment. The court basically said a confession by which life becomes forfeit must be the expression of free choice. A statement to be voluntary, of course, need not be volunteered, but if it is the product of substantial pressure by the police, it does not issue from a free choice. When a suspect speaks because he is overborne, it is immaterial whether he has been subjected to a physical or mental ordeal. Mental compulsion is prohibited by the 14th Amendment. To take a better look at this and to see how it really operates, let's look at Spano versus New York. In Spano versus New York, we had a young man who was a recent immigrant into the U.S. He got into a fight with a person at a bar. In the fight, he was beaten pretty badly. After the beating, he said he was dazed. He was kind of mentally distraught, or mentally out of it, I would say. He went home, got his gun, came back to the store where he knew a person would be, and he shot and killed him. After he shot and killed him, Spano went on the lam. Eventually, he called an attorney. He called an attorney. And attorney asked him to turn himself in. But before he did that, he called a friend of his, and it was a friend of his whom he had grown up with and the friend was also a fledgling police officer. He was in training to be a police officer. He told the friend what had happened. He told the friend that he had taken a really bad beating and that he came back and he killed the person. He had done something very terrible. Friend has suggested that he should turn himself in. His attorney had him to turn himself in, and he told him not to answer any questions without his presence. He turned himself in. The prosecutor brought him in, and they began to question him. They began to question him, and he said, I want my attorney. I will not answer any questions without my attorney. They tried several times to question him without his attorney. He gave the same response. I need my attorney. I will not answer any questions without my attorney. And then, remembering that he had a friend in the police academy, they called his friend in and they coached his friend. And he told his friend to go in and to play on his sympathies, basically, to play on his mental intellect, and to tell him that he needed to get a confession in order to retain his job. They tell him that the confession would help him. It would not only help him, but it would help the suspect. And so the friend went in and he tried to get a confession from the friend, from the suspect. Did not work the first time. The prosecutor, the authorities asked the friend to go in, or had the friend, the fledgling police officer, to go in again, and told him that his family would be in jeopardy, that he needed this job, and just several things. He kept cajoling him. He kept encouraging him to give a confession. He kept using these ploys to play up on the person's susceptibilities, to play up on their friendship, to play up on his sympathies. And the court basically held in Plano. The court said that the confession, to be consistent with the 14th Amendment traditional principles, that it had to be consistent with the 14th Amendment traditional principles, that police must obey the law while enforcing the law, that in the end, life and liberty can be as much endangered from illegal methods used to convict those thought to be criminals as from actual criminals themselves. The court found the following factors in the totality of the the totality of the circumstances constituted substantial police misconduct that caused an involuntary confession. First, Spano was young, foreign-born, relatively uneducated, emotionally unstable, and inexperienced in the criminal justice system. Second, Spano did not make a narrative statement, but was subject to leading questions of a skilled prosecutor. Third, he was questioned virtually incessantly by a number of officers throughout the night. Fourth, the questioning persisted in the face of his repeated refusals to answer on the advice of his attorney. Fifth, the officers ignored his reasonable request to contact the local attorney whom he had already retained. And sixth, the most important thing in this case, the use of his friend Bruno, Spano's friend, and Bruno's false statement to Spanos. He gave him false statements. He used those false statements to encourage him in order to give a confession. The court said that these things overbore the suspect's will, and the state engages in ploys that overboard the suspect's will, and his confession becomes a confession as a result of the pressure that the state has placed on him, and not given for some other reason. It is not freely and voluntarily given. Therefore, it violates the due process clause of the 14th Amendment. And here the court found that it violated the due process clause of the 14th Amendment. So the question becomes, what is the effect of police deception or psychological ploys on voluntariness? Let's look at one case, Green versus Scully. Green was taken to the police station and interrogated. He was threatened with the electric chair, told that all the evidence needed to convict him was in place. The police used a good cop, bad cop tactic. Green stated that he would never confess because he could not face his or the victim's family. An officer stated he would get Green psychiatric help, that Green could say he was mentally ill when he committed the murder. Green stated he confessed out of fear of hurting someone else, and he needed to get psychiatric help. So he said that I'm confessing. He said that he gave the confession out of fear of hurting someone. The court held that this confession was voluntary. Even though they used a good cop, bad cop tactic, they threatened him with the electric chair. had told him that all the evidence that needed to convict him was in place. They had lied to him. But the psychological ploy that they used did not overbear his will. That was some of the reason for which he confessed. That is, to prevent himself from hurting someone and also to get psychological help. All of the evidence must be weighed with the totality of the circumstances. The tactics were not dispositive because the court concluded that Green has its own motivation for confessing. All of the evidence weighed together did not overbear Green's will and bring about his confession. He confessed, as he admitted, because he was afraid what he had done to the victims in a blackout would be something he was going to do to his own family. Look at Florida versus Kayard. In Florida versus Kayard, the police used fabricated scientific reports as a ploy in interrogating the defendant. They used scientific reports that looked like official reports for the purposes of interrogating the defendant. The court said that these reports, because they appeared to be official, overbore the defendant's will, and he confessed as a result of the official reports that they had shown him or given to him. The court found that the resulting confession to be involuntary. A suspect is more impressed and thereby more easily induced to confess when presented with tangible, official-looking reports. Psychological ploys by the police wholly illegal. The court has said no. The psychological ploys by the police are not wholly illegal. Look at Miller versus Fenton. It involved an interrogation in which the detective falsely told the murder suspect that the victim was still alive and could identify her attacker, and that bloodstains had been found at the suspect's home. Throughout the interrogation, the officer portrayed himself as sympathetic to Miller and told Miller that he did not consider him a criminal at all, that was deserving of punishment, but he was a sick person that needed medical help. Miller eventually confessed. The majority stated that it is generally recognized that police may use some psychological ploys in eliciting a statement from a suspect, as long as the decision is a product of the suspect's own balancing of competing considerations. The confession is voluntary. So he must have enough information in order to make a measured decision. He must have enough information in order to make a decision based upon something other than the ploys that are used, psychological ploys that are used by the police. In our view, the manipulative tactics used here did not produce psychological pressure strong enough to overbear the will of a mature, experienced man who was suffering from no mental or physical illness and was interrogated for less than an hour at a police station close to his home. Are promises of consideration coercive? What if officer promises defendant that any cooperation given by him would be brought to the prosecutor's attention? Promise of consideration. That is not a ploy that will overbear the defendant's will. The court has held a false promise of lenience would be an example of forbidden tactics, for it would impede the suspect in making an informed choice. But government is not forbidden to buy information with honest promise of consideration. So a false promise of consideration that we're going to get you off. We're going to get you off and you're not going to get any time. As a matter of fact, we talked to the prosecutor. He's told us that he's not going to even prosecute you or bring the case. A false promise of consideration is not enough for him to make an informed choice. But the government is not forbidden to buy information with honest promise of consideration. We'll talk to him. We'll do the best we can to try to get him get your reduced sentence. That is not a ploy that's going to overbear his will. Threat of physical violence. Defendant was suspected of murdering his stepdaughter in Arizona. He became friends with an inmate who was a paid informant by the government. The inmate befriended him, and the inmate told him that it's really hard to make it here in the prison, but I know how to protect people. And if you tell me what happened, you tell me what went on with the crime that you're here for, that I will protect you. I'll make certain that you're not hurt while you're in here. The court said that that was a threat of physical force. The court concluded that a credible threat of physical force had existed and that defendant confessed due to his misplaced hope of protection from that violence. Therefore, the confession is involuntary. And so if you make a statement for the purpose of saying that I'm going to protect you, otherwise you're going to be hurt, there's going to be some violent outcome, then that also is a threat of physical violence. So threats of physical violence or circumventual threats of physical violence is a threat that overbears the person's will. Now, the premier case that I want you to take a look at that really defines how we're going to look at the 14th Amendment and confessions is Colorado versus Connolly. Connolly came to downtown Denver, met a police officer, and just out of the blue, Connolly said that, look, I've traveled here, I've come a long distance, and I want to tell you about a murder that I committed several years ago. He actually described the murder. He actually told when the murder occurred. Police officer Mirandaized him and told him, look, you do not have to give me a statement. You don't have to say anything else. He said that anything that you say will be used against you. Connolly said, I want to talk. Connolly talked. He gave a confession. He gave a confession that led to the body of a woman that had been murdered several years ago. After Connolly gave the confession, his lawyer came in. The lawyer told him not to talk. Connolly suggested that at the time that he gave the confession, that he was mentally unstable. There was actually medical evidence. Psychiatrists had said that he was suffering from hallucinations, that he was not mentally stable at the time that he gave the confession. The court had to make a decision as to whether Connolly's confession could be used because based upon his proposed or supposed mental disabilities at the time that he gave the confession. The court said that there are two things that must be considered if we're going to find that a confession is in violation of the 14th Amendment due process clause. Only if it were established a brand new constitutional right, the right of a criminal defendant to confess to his crime only when totally rational and properly motivated could respondent's present claim be sustained. Respondent would now have us require sweeping inquiries into the state of mind of criminal defendant who has confessed. Inquiries quite divorced from any coercion brought to bear on the defendant by the state. The court said, according to Connolly, the defendant must first, if he's going to show that his confession is not freely and voluntarily given, make it showing that police subjected him to coercive conduct, whether it's psychological or whether it's physical, that there was some coercive conduct that the police subjected him to. And he must also demonstrate that the conduct operated on him, given his particular characteristics of susceptibilities, conditions, and the conditions of interrogations to produce the involuntary statement. He must show for coercive police conduct, and not only show coercive police conduct, but also show that they operated on him due to susceptibilities that were known by the police officers at the time that he gave his confession, and they operated on him to force him to give that particular, along with the police coercion, to give that confession. Then his will would have been overborne, and therefore his confession would not be a good confession. Thus, the mental incapacity of the person at the time that he gives a confession does not affect the voluntariness of the confession unless you can show police coercion and also there were known susceptibilities that they took advantage of. So, under Connolly, the 14th Amendment must be judged using those two principles. You must show police coercion and them taking advantage of some known susceptibilities of the suspect. Now, with that, we're going to stop. We're going to end with our 14th Amendment analysis of confessions. Do not forget the 14th Amendment analysis of confession. Do not forget Connolly. Do not forget that there has to be something that will overboard. The state must engage in some activity or some tactic, some coercive tactic, according to Connolly, that would overbear the person's will, combined with some susceptibilities or known susceptibilities that that the state may be aware of. If there's no known susceptibilities that the state may be aware of, the only thing you look to is the coercive conduct and whether it overboards will. But if there are known susceptibilities, you look at what the state did and those known susceptibilities and whether the combination of the both will overbear a person's will. Do not forget that. That's the step that you have to take when you're looking at whether confessions are good. It's not only the Fifth Amendment. We'll cover the Fifth Amendment story with Miranda in the next session of this particular uh, discussion. We'll talk to you about Miranda in the next video. Thank you. Goodbye.